member for Warringah.
Thank you, Mr Deputy Speaker. And I would like to note and thank the Attorney-General and his office and team in their engagement in relation to this bill and then the subsequent amendments that we now see. As others have said, it is so important that we have trust and faith in important institutions. As I noted in my speech yesterday, the Australian Administrative Tribunal, the Administrative Appeals Tribunal plays an incredibly important role because administrative decisions touch on so many areas of people's lives. And it is important that they be able to have a fair appeals process and a timely appeals process to that. And we know the AAT, as it was not working well. As a previous barrister prior to politics, I was very aware of the difficulties and the problems with that body. And it had been politically stacked. So I very much supported the Attorney-General's decision to abolish the current the AAT as it was and replace it with the Administrative Review Tribunal. But there are several elements that were incredibly important to insert into that bill, and it's good to see the government coming to the table constructively and now seeing these amendments being presented. The member for Mackellar moved amendments in relation to the appointment process, making sure that we have a robust merits process to these appointments, but also an independent panel to ensure that when the Attorney-General exercises discretion in relation to appointments, it is picking from people that have been assessed as qualified and capable for the role, and not just a politically stacked appointment. What's also important is it is so important that administrative appeal bodies like this are independent, impartial and free from politics. Australians must feel like they're going to get a fair hearing before an administrative review body that can make key decisions affecting their lives. So the number of amendments now being moved by the Attorney-General are very much welcome, and they in large part address a number of the concerns that many of us have had. A concern I raised was in relation to the statutory review, because we are where we are because the previous body had fallen so far from its original purpose and intent and was not working well. It was politically stacked. So the amendment the Attorney-General now has presented, has tabled, reflects the amendment I was offering, and I very much welcome that, especially in relation to all the engagement that there's been in relation to this issue. And I know many individuals and organisations called for such a review clause to be included in the legislation, because we're not infallible and we need to make sure through a legislated review process that the intended changes work as was meant to be. And I'd like to acknowledge the work of Catherine Williams from the Centre of Public Integrity on the work she's done with my office and I assume others in relation to the concerns. The statutory review clause the government is offering is a little different. Firstly, it's providing for a review to occur within 5 years rather than the 3 years as I had proposed, but I accept that there is a timeline and process. But secondly, the review panel is left to the minister's discretion. There's no description included in the Act or the amendment of what the reviewer's qualifications should be. This does contrast to the membership of a review panel that I had proposed with my amendment, specifically that it must be comprised of 3 members appointed by the minister and include a former judge of the High Court of Australia, of the Federal Court of Australia or of the Supreme Court of a state and territory, a person with experience in community advocacy and engagement relating to matters dealt with by this Act, and a person with significant knowledge or experience relating to matters dealt with by this Act. So those 3 qualifications help give confidence that in the review process, the review panel will have necessary skills. So I do put the question to the Attorney-General: how will he ensure that those appointed as reviewers for the statutory review will be appropriately qualified, or what is, in fact, does he have in mind or is intended in the provision for appointment of a statutory review panel?